Assalamualaikum to my beloved lecturer, Dr. Azrin, and my fellow friends. Today, my group members and I will present about topic Insurable interest of case Zurich General Takaful Malaysia Berhad and Rashid King Abdurrahman versus Muhammad Riza Ma'ranin Abdul Har Ali Hussein Wan Ismail Wan Khadir. So let's start.
This case starts with an accident that happened on May 17, 2020 at Jalan Kubang, Ikan, Kuala Terengganu. It involved a motorcycle driven by the second defendant and a car owned and operated by the first defendant. During the accident, the second and third defendants suffered injuries both the motorcycle and the first defendant automobile were involved in the accidents. The second and third defendants filed a lawsuit in the Kuala Terengganu Sessions Court against the first defendant and the second plaintiff requesting reimbursement of their injuries from the accident. The registered owner of the actual motor car is the second plaintiff. Considering all this conclusion, it granted the originating summons with cause.
The issue for this case is whether the first plaintiff, which is Takaful Company, liable or not for any judgment related to the accident that occurred the second defendant and the third defendant. The law applied to the case is Section 96 to Road Transport 1987. The user of vehicle has insurable interest in third-party injury liability. In this case, the first defendant's motorcar, the second and third defendant's motorcycle were involved in the incident. During the accident, the second and third defendant were injured. Because of that, it's allowed the second and third defendant enforce any judgment obtained from the accident against the first plaintiff. But when the first plaintiff filed an originating summons, it was discovered that the certificate of takaful was issued for the chassis number of the actual motorcar, which is different from the chassis number of the first defendant motorcar. The second plaintiff is the registered owner of the actual motorcar, which is the subject matter of the issue. The second plaintiff filed a police report after being notified of the accident suit, denying the involvement of the actual motorcar in the accident. According to the police report, she stated that the actual motorcar was in an accident in 2011 and was declared a total loss by Syarikat Takaful Malaysia Berhad. She had consequently surrendered with the actual motorcar, so Syarikat Takaful Malaysia Berhad paid the second plaintiff RM9,400 as full and final settlement of her claim on 5 March 2030. Syarikat Takaful Malaysia Berhad additionally verified that they still have the original registration card and key to the actual motorcar. According to Section 10(3) Road Transport Act 1987, state that no motor vehicle is allowed to be registered unless it's clear, distinct, unaltered engine and number chassis. The reason for this were the chassis number and engine number rather than the registration number figure out the identifier of vehicle. In this case, the actual motorcar, which is covered by the certificate of takaful, is not the first defendant's motorcar, and the motorcar is a clone car with the chassis number tempered to resemble the chassis number of the actual motorcar. It has also been confirmed by Jabatan Kimia Malaysia that the chassis number of the first defendant's motorcar has been tempered, that was revealed by electrochemical processing. The court held that It is clear in the case that the first defendant's motorcar is not the vehicle covered by the certificate of insurance. As a result, the first plaintiff is not insurer of the first defendant's motorcar. Then the first plaintiff is not liable for any judgment obtained by the second and third defendant in the accident suit. Furthermore, the receiving compensation for total loss of the actual motorcar in 2013, the second plaintiff no longer has possession, control or usage of the actual motorcar.
Moving on to application. To begin, as mentioned in Marine Insurance Act 1788, the second and third defendant are not able to get the reimbursement for their injuries from Takaful company, as the company doesn't have any connection or responsible with the consequences that happen to the second and third defendant, as the third and second defendant are not the insured of the company. The Takaful company only covered for the clients for any events that might happen to them based on the agreement. Next, under Section 96 Road Transport Act 1987, the second and third defendants suffer injuries because of the accident. Therefore, they have the right to compel to the first defendant to pay for any damages resulting from the accident. However, in this case, the second and third defendant are not able to do so, as the Takaful company is not liable for this action of the first defendant. This is because the first defendant has tempered and cloned the actual car that was involved during the accident occurred. Lastly, under Section 10 of the Road Transport Road RTA 1987, it was discovered that the first defendant has cloned the actual motorcar and altered the chassis number. This action resulted in Takaful company have nothing to do with any insurance related to the motorcar. The actual motorcar has a different chassis number and engine number from the submitted one.
So, in conclusion, the first plaintiff, which is Takaful company, is not liable for any judgment related to the accident that occurred to the second defendant and third defendant, as the initial plaintiff is not the underwriter for the motorcar belonging to the first defendant.